Okay.
Chief Judge Glanville, at a certain point, because we were receiving late discovery disclosures all the time.
Okay.
And at a certain point, he said he was fed up. He spoke to the state. He said he was drawing the line there.
Okay.
And that any late disclosures after that, and he did exactly what you did today. Maybe not in those exact words, but he said, is there anything else?
Okay.
So he gave the state this opportunity already, and he told Ms. Love specifically that if any other late disclosure of discovery came after that date, that it would be met with remedies and sanctions.
So basically everything that she's saying she was missing or they didn't get was all included in the actual indictment.
The 2nd, 2022.
All right.
And the folder specifically that the number and the name appear in the discovery served August 2022, it's folder 1, counts in indictment by act 181 through 182, Sumlin, Dorsey. Count 55, 181 through 182, discovery 2, Dorsey conspiracy. And it is the 6 call down.
Okay.
Which has on it, and I will submit this as states 1 for the purposes of today.
Okay.
It has the phone number 470-957-2893 - Dorsey and Boyer.
All right. Okay, that appears to clear up that issue. Y'all can double check and make sure it's, says what she said it said.
Looks like that might be it.
I don't know. Let's ask.
What was the question? I missed it.
Can I pass it around or I'll give it to the court first?
Sure.
We just screenshot the trunk.
Okay. If y'all got a screenshot of it, maybe send that email around to everybody so they can see. But
and also, we sent it a second time when we organized the discovery for the defendant. So it's in 2 different sets of discovery. The first one is from August 2022.
Okay. I mean, I'm happy to pass that around at the time because she's got it highlighted. Y'all can all take a look at it, but she's going to email, or she or Mr. Atkins are going to email that as well. And then it sounds like it got reserved later in 2022. All right. And then, do you have hands on the affidavit and search warrant yet?
I label it states 2.
Okay.
So it looks like Miss Love might have covered herself. We'll have to wait and see what the defense says if they bring anything else up.
I guess the court reporter is asking about the labeling. So yesterday we had a states 1 and 2, and we sort of had a motion, I guess, with regard to, I guess that was.
We labeled it differently. We labeled it states 1 Melnick proffer.
Okay.
We labeled today's states exhibit 1 as states exhibit 1 August 7th. 2024, if that's today's date.
Okay, so it's weird, I guess, because I'm sure there are 100 million, I exaggerate, but a number of states exhibits that have already been in for the jury trial. We're sort of paused on the jury trial and kind of we're doing motions in limine for the most part, really, sort of, but this isn't that either. This is, I don't know what to call this. Just don't know what to call this. To the
supplement to discovery.
Say it, states 1 and 2 to the
what do you call it?
Boyer discovery matter.
Okay.
How about that?
Yes.
It's crazy.
Okay.
Shout out to SMB. We're just waiting to see what Miss Love says about
Can we get a stapler?
the information that the defense is saying she didn't give.
I've got some paper clips.
I think we know where it's secretly kept. And if not, just switch it.
I mean, I'm not stapler.
If you want your own,
A stapler?
It's fine.
that would be perfect, Ron. Thank you.
I mean,
Thank you.
gotta give it back to me now.
Can I respond to what we're talking about?
Yeah, come on up to the.
I'm not sure if anything's being cured or.
Well, I don't know.
So let me
Here we go.
first start
What's the
off
mask
by
gonna
saying
say?
that the discovery in this
SMB.
case, including I call them dumps, whatever okay, 1 and 2 came together. And all the different additions, 3, 4, all the way up to, I think there was 13 or 12, they're divided by counts.
Okay.
Okay. So count 55, I believe.
Is the conspiracy is connected to the Drinks murder, right?
No, it's not.
No? Oh.
No. That's one thing. It's a conspiracy. It's count 55 in this indictment, which involves
The murder of Harold Clements,
Well, he's not dead.
right?
well, that's not in this indictment. It involves
What is in this
I'm sorry.
indictment? It's not a
The
count
overact.
against anybody. The count 55 is not a count against any of the 6 co-defendants on
Correct.
trial currently. Yes.
correct. So it involves something completely and wholly unrelated from
Okay.
the Drinks
Right.
murder.
True.
Okay. I want to play for you. So I can show Your Honor the screen, but basically if you click on that jail call, which I guess is Mr. Dorsey talking, it comes up on your screen. It says 0428-2022. I guess that's the date, 4/28/2022. And it says 2218. And then it says a phone number, 470-957-2893. And it says Dorsey and Boyer. Okay, it doesn't give a first name. It just says Dorsey and Boyer.
Okay.
There's no context for us to know
like
who
we're
Boyer
splitting
is.
hairs
And
a little
this is the call that the state is saying puts us on notice that Mr. Boyer is somehow suspected and involved in the Drinks murder.
Okay.
This is the call, and I just want to play it.
Okay.
Your Honor, Mr. Sharp, Your Honor, if I may just make one point of clarification. We did not represent and are not representing that. The content of that call puts them on notice. What we are saying is that the wiretap, the content of the calls in the wiretap are the basis for our search at getting the records. That's
Okay.
what put us on
And the connection to the Drinks murder, but it is this service of discovery that says, hey, that phone number from the wiretap is connected to the name Boyer. Is that what you're saying?
That's what we are saying.
It says
That's all I'm
Boyer,
saying.
and it just says Boyer. And if you play this, I would like to be able to play
Sure.
this.
This is a free call from
You already know who this is. Shout it out.
an incarcerated individual.
That's Mr.
at
Dorsey.
Cobb County Jail. This call
All right.
is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Oh, that's it. Oh, the fuck going on? The fuck blaze? I'm in traffic, so I gotta hit that. Alright, I get back at you. Too good.
That's it.
All right.
So someone says, I'm in traffic, I'll hit you back.
All right.
And
Okay, no, and Ms. Love's clarification is it's not that call that gives you all that notification. It's the wiretap that gives you the notification because the wiretap has all these communications back and forth between this phone number, 404-957-2893, and Mr.
bit.
Garlington's phone number.
She had her stuff
and
together.
then it's this bit of discovery that Ms. Love just told us about that says, and that phone number belongs to somebody last name Boyer. Okay, but they say they're not using it in the Drinks murder evidence anyway. So that actually, I think, takes care of Mr. Williams' motion in limine filed very recently within the last hour or so, I think, saying keep that out. Is that right? And I have to confess, I have not asked you that particular motion, looked at it myself yet. I'm just basing it on Ms. Pursfield's review of it. Is y'all are saying we want that kept out, and the state's already maintaining they will not introduce it. And so, yes, granted, but also unnecessarily so.
Thank you. Well, I added not only case in chief, but in rebuttal for that, Mr. Boyer. And then there's a second part to it. We received on Monday for the first time,
to the Truman Show,
Agent Bernie's expert report as to a April 26, 2015 shooting of Mr. Carter's tour bus.
Okay.
It's been referred before this honorable court as the Lil Wayne bus shooting.
Okay.
And the state has already put up, they said they didn't need to qualify Agent Racy. He's with ATF now. He's former detective in Cobb County. Racy, which is, I'm going to tell you, R-A-C-C-I, but I may have misspelled that. They've already put up painfully. It took days tracking phones. They have 3 to 4 different exhibits to your honorable court's right of your bench. They're against the wall, or they should be. I believe that's what they are. Anyway, the point I'm trying to make is now, for the first time, we're getting another expert.
Okay.
Never gave us this information before. And yes, I've had the records. I'm not complaining about that. But, you know, we look at everything and we test everything with our own independent experts. So I want that excluded too. That was in the motion as well.
All right. So with regard to, that's two entirely separate, the issue I realize is way late discovery is what is being alleged. But we're talking about two different sort of pieces of evidence. So with regard to this Boyer plotting of the wherever the cell phone location is, the state has represented that they do not intend to use this. I'm granting the motion limine with regard to particularly is at least this case in chief. But with regard to if it potentially needs to be used in rebuttal, at this point, y'all are on notice. Yes, it should have been produced before now, but we're also, I would say, pretty far away from hearing any evidence about the Drinks murder anyway. I am not going to make a blanket ruling at this point that it can't come in rebuttal either, because y'all got time. I don't know if it might need to be used or not. I don't know, but I'm going to leave that for another day if and when it does come up. Now, with regard to this second sort of chunk of information that's just been produced, Agent Bernie's analysis of what does that have to do with cell phones too, or just the incident?
He's a cell phone expert, so that's what it deals with.
Okay.
And it's
okay. So what do you say as to that, Ms. Love? Because if y'all have already presented your evidence, or what's your plan with regard to Agent Bernie's report and analysis?
Your Honor, would the court permit me to address the first part regarding the Boyer records and tender the evidence, and then address the second part of the motion? Okay. So the state is tendering for the court's consideration States 2A Boyer records, which is the affidavit for the search warrant, and states 2B, Boyer records, which is a search warrant itself for the cell phone records. And the court is correct. We stated earlier and state again that we are not attempting to use them in our case in chief. As well, Your Honor, I am marking as State's Exhibit 2C, Boyer records.
Mm-hmm.
It is a screenshot of a search of the wiretap data for the number of calls.
She gave us what she was supposed to.
470-957-2893. And the number of calls within the wiretap that involve this number are 501. So I'm tendering this for the court's consideration.
All right. Thank you. And 1 as well as 2A through C are admitted. Okay. Turning now to the Bernie
set
matter.
of plots regarding the Little Wayne bus shooting, the data, the cell phone records, and their cell site location information was turned over, I believe, in July of 2022, if I am not mistaken. I'm almost certain that we turned it over in the first set of discovery that we served. So the data that the plots are derived from have been in defendant's possession since July of 2022. The plots that are that were made at the request of our office were requested after testimony and cross-examination, testimony elicited from through direct and cross-examination of our witnesses in the Little Wayne bus shooting.
Shout out to the Truman Show. Drops a 5 bomb.
Some of the
She is Truman Show. I agree. I agree 1000%. Oh, we got a little bit of buffering. Fix that.
The Little Wayne bus shooting.
Okay.
As a result of some of the questions and answers and the direction that we saw that questioning going, we asked for the plotting of the...
And when did you ask for that?
I'll get an exact date.
Give me a ballpark.
So now she's trying to take shots at the defense?
Hold on.
Give me a ballpark. Well, when did these...
Boss says, yeah, loves dragging out what a good prosecutor she was by giving them the Lil Wayne bus shooting evidence. Yeah, she's seems like she's unprepared. That seems to be the biggest thing.
In the last 6 months, that's the
disgusting, Tabitha.
Narrower ballpark because things were delegated and we did.
Okay. When did these people testify to the Lil Wayne shooting? When was that testimony, roughly? January, June, April? Okay. So at some point after April.
That's a good one. Yes.
She's texting Miss Hilton right now. Help me.
Okay. Let me ask you this. At the point in time when you think it might be relevant to have a plot of whatever cell phones might have been involved. We've already heard everybody's testimony. Man, we'd like to shore that up with some expert rolling back in here and taking the stand again. We're going to get him to plot this. Mm-hmm. Would it have been possible at that point in time to share with the defense, hey, y'all, we're going to have our expert that y'all already know about anyway go ahead and plot this too?
Yes, that would be. Yes.
Okay. Why was that not done?
So Bernie did not testify about these. He has.
I know.
Okay. Your Honor, if I may, I'd like to give the court first the more precise time that we got.
Come on, records. Lady, get it
not
together.
When you asked for them, not when you got them. When you asked for them.
That yes. Before I go to that second question, with the court's permission.
Okay. Go ahead. How long is it going to take to get that information? Can Mr. Christian work on getting that information?
It's already being worked on. I already.
Okay. I mean, will the answer differ based on when you asked for the information as to why at the time you asked for the information, no matter when that was, you did not, even though you could have, say to the defense attorneys, I'm going to be getting this. I don't know if I'm going to use it or not, but I'm going to be getting it.
That is the best practice. And we did not, but I don't have
a good answer. I mean, and the answer could be because, man, they're only 20.
She is continuing to cook Miss Love. What is going on, man? Judge Whitaker is sick of this lady, as are all of us. Good Lord. Why is she here? I mean, I'd rather get Fanny in here at this point.
I mean,
she's making Miss Hilton look like a superstar.
On when you asked for the information as to why at the time you asked for the information, no matter when that was, you did not, even though you could have, say to the defense attorneys, I'm going to be getting this. I don't know if I'm going to use it or not, but I'm going to be getting it.
That is the best practice. And we did not, but I don't have
a good answer. I mean, and the answer could be because, man, there are only 24 hours in the day and this is chaos and, you know, we're doing the best we can. That could be your answer. I don't know. It's still not a good answer.
Yeah, we know.
But
embarrassing.
Let's just maybe nip this in the bud. Because I did ask you also to, at the lunch break, huddle with your team and see if there might potentially be anything else outstanding, whether Brady or not, because none of this sounds like Brady. It's just information that might come in trial that it would be, you know, just kind of like the way we're supposed to try cases is to sort of share each other's evidence to, you know, with the other side so they know what to expect. So were you able to sort out yet? Is there anything else out there in the universe that you think you're going to use?
Judge, I used the lunch break to get that information I gave to you earlier. We were feverishly getting that.
All right.
So
feverishly, huh?
All right.
Right now, what I have for the court is that Racy testified on between May 13th.
Have you ever had a dream?
So I need to clarify that.
Okay.
I found the video of Miss Love.
Have you ever had a dream that you want.
What the fuck are you talking about?
There's Miss Love.
The defense challenging him and as I said earlier, the questions and answers and the follow-up cross-examination elicited during that time period, May 13th and May 16th, is what caused us to request them.
Okay, that's fine. Okay, and essentially you acknowledge, yes, we could have gone ahead and let the defense know we were going to try to get this plotted. You just didn't. And I guess what I need to have happen going forward is that as this trial is going on, First, if there's anything outstanding like that, whether you've got results back
crazy.
or not, or if you're just like, after somebody testifies, you know what? This would be a good thing.
Okay.
Share it in a timely manner, which is like, not necessarily at the time it occurs to you, but at the time you decide to do it.
Okay.
Don't wait for the results to get back. Don't wait till you're going to call the person to the stand. At the time you say, we're going to do this, you give that information to the defense, okay? And then when you do get the results back, you can say, we're not going to use it after all. Or, we are going to use it, here's the result. And that is going to go, be the rule, be the requirement moving forward for everything. So if there's anything out there right now that's kind of in progress, tell them about it.
Okay.
Oh, I found another video for y'all. I found another video of Miss Love. Y'all have probably seen this one.
Burn the damn
I had to cook
sandwich.
for this nigga. How many days when he spent the night at my house? Like 6. I had to cook this nigga spaghetti and shit because he was hungry. The fuck wrong with you? Nigga can't eat a fucking sandwich cold. Look, this nigga trying to cook a motherfucking damn ham a fucking sandwich. This pussy ass nigga burn a fucking sandwich. Why the fuck you ain't eat it cold? Nigga, you can't even cook a damn cheese toast. Yes, you can't. Nigga.
There she is.
Moving forward, as things come up, when you decide I'm going to be doing something about this, tell them about it. Okay?
Yes, sure.
So what amount of time do you need to get with your team and figure out, is there anything in process?
See, this Judge Whitaker, come on. Please stop. Hold her in contempt already. I don't understand why she is getting this much leeway, why she's getting this much time to do something she was already asked to do. Now, this is the third time. I don't understand it. I don't understand this at all. It's very confusing. And also shout out to Amy in the building with the 5 bomb. She says, what did she say? SMC Inc. I'll cover your super chat. Thanks for supporting the channel. Shout out to Amy. She means it too. She is not lying like Hollywood Co. Here we go. Yeah, I'm ready to get out of here too, Truman Show. This is embarrassing, man. It's embarrassing. I want a refund. Oh, now we're buffering a little bit. Let's rewind some. There we go. Or maybe not. What's going on, Law and Crime? Y'all bear with me a second. Shout out to Ronnie Hancock. He says, this is just messy and unnecessary, putting everything on the table so it's fair for everybody. All this half-baked stuff is just crazy. Thug gotta be like, come on now, this is some BS. This is bad.
Your team and figure out, is there anything in process?
She asked her how long it's going to take.
Friday at 5 too late? Or you want me to do
Friday at lunch. Okay. Well, okay. I don't know what our Friday is going to look like, but
Friday at
yes,
lunch.
you can share it with them without it being in court. So yes, Friday by lunchtime. And you can just copy Miss Percifield on whatever it is you tell them.
Okay.
All right. And
she's giving them so much grace.
I expect that
It's
to
crazy.
be the rule that gets followed moving forward. Okay.
Yeah, I don't understand.
Any questions about it?
No.
Okay. All right. Anything from the defense on?
Shout out to Mr. Tesla. Dropping the 5 bomb. We're still buffering over on Law and Crime. Let me see if I can get this to work. I might have to refresh. Let me see. We're at 7 minutes behind. Let me refresh this screen, y'all, and see if I can get it to work. Yeah, Lauren says she is. Yeah, she's giving them a lot of grace.
And then you don't do that.
Bad faith would be.
Sounds like she's still putting the heat on her too. Thank y'all for the super chats, man. I do not ask for super chats, but I appreciate it. Shout out to everybody who's in here dropping the super chats. We had Mr. Tesla, Amy in there. We had SMC Inc. in the building. We got the Truman Show up in here with another one. Says she feels bad for love. She rode the short bus. Oh, God. Hey, yo. It's tough out here. I don't know what's going on with law and crime. Maybe it's me.
And
here we go. Here we go. It should be good now. And it looks like my YouTube for some reason is buffering too. Let me check one more thing. I
expect that to be the rule that gets followed moving forward. Okay.
Oh, I picked the perfect spot.
Any questions about it?
No.
Okay. All right.
I always pick the perfect spot.
Anything from the defense on that topic and that rule? And I know it is not ideal, but
shout out to Room 9, Anton Daniels.
This, it seems that up until recently, this trial was sort of everything was on a rolling basis. And I can't do a whole lot about that, but moving forward, that's what it's going to be. Yes, ma'am.
So, Your Honor, that's everything was, everything was not on a rolling basis.
Wow.
And the rule that you just implemented was already the rule.
Okay.
Chief Judge Glanville, at a certain point, because we were receiving late discovery disclosures all the time.
Okay.
And at a certain point, he said he was fed up. He spoke to the state. He said he was drawing the line there.
Okay.
And that any late disclosures after that, and he did exactly what you did today. Maybe not in those exact words, but he said, is there anything else?
Okay.
So he gave the state this opportunity already, and he told Ms. Love specifically that if any other late disclosure of discovery came after that date, that it would be met with remedies and sanctions. So we're here again, and I'm just asking that before you exercise patience,
don't exercise patience. Okay. That it was already supposed to have been in place and be aware of that. Okay.
Yeah, I mean, Judge Whitaker, this is normal in court. You're supposed to have everything in a timely manner. And Miss Love's up there frozen because she knows she messed up. Shout out to Amy for the 2 bomb.
So, I think that's probably true. I wouldn't be the least bit surprised if Judge Glanville had already at some point said,
why does he have to say that?
Judge Glanville
sort all this out.
In fact, he has and did in fact say, hey, turn over everything you have.
Right.
And
stop talking,
I only
lady.
say that as trial goes and as we see the direction that.
Okay. I understand. Yeah. I mean, trials are kind of living things. I get that. But even if it took you 2 weeks to decide, so like by, Memorial Day weekend on May, whatever it was at the end of May, you were like, yeah, let's get this. It's now August. So you had all of June and all of July. So, I mean, the motion on the floor is to request